Thank you everyone for joining us. Please hold for a minute. We're going to have a few more commissioners joining shortly. Thank you everyone for joining us. Commissioners, I'm now turning on your ability to start your video and audio.
Mr. Chairman, whenever you'd like, I think we're ready to go.
Right. Appreciate it. Thank you. Welcome, everyone. Good to see you all again, as well as our new member who I'll address in just a moment. This is the hearing on the California Environmental Quality Act, Part 2, for Thursday, April 13th, 2023. Good afternoon. I'm Pedro Nava, and I'm the chair of the Little Hoover Commission. Again, thanks for joining us. I want to introduce the other commissioners who are here with us on Zoom. We have Vice Chair Sean Varner, as well as Commissioners David Byer, Anthony Cannella, Bill Emerson will be joining us soon, and Gil Garcetti, I'm sure is on the way, along with Janice Sidley. And let me take an opportunity to welcome our new commissioner, Jose Atilio Hernandez. And if Commissioner Hernandez, if you'd like to make a few remarks, now would be a good time to do so.
Thank you, Chairman. Hello, Commissioners. Just want to say what an honor it is to serve. I've been in and around the building for about 25 years. And so I have followed the Little Hoover Commission. I have read the reports. I know how incredible the tasks are in terms of coming up with solid solutions that are really efficient and effective, and I look forward to serving. And that's about it. Quick background, CEO of IDA California. We focus on a lot of work with philanthropy, nonprofit, for-profit, and government, and have a nonprofit IDA Labs as well. Thank you.
Wonderful, and welcome again, and thank you. We're glad to have you joining us. We also, there are legislative members that may be joining us. We have Assembly Member Philip Chen, Senator David Min, and Assembly Member Liz Ortega. We will have a new representative from the Senate, Senator Scott Wilk, I understand, was approved yesterday through Senate rules. We also have commission staff, Executive Director Ethan Rarick, Deputy Executive Director Tamar Foster, Analyst Ashley Hurley, Allie Powell, and Shara McAllister, as well as project managers Crystal Beckham and Tristan Stein. Let me do a little bit of housekeeping before we turn to our subject. Commissioners, your audio and video will be turned on throughout the duration of the meeting. You may mute yourself if you wish. Please remember to unmute yourself if you want to make a comment or ask a question during the hearing. During the course of the hearing, I will search for raised hands or some indication that you want to say something or ask a question. The video and audio of our hearing witnesses will be turned on when it is their opportunity to present. Members of the public will be muted. We will have a public comment session at the end of the hearing. Those who wish to make a comment will be unmuted during that public comment session. If you want to make a public comment, please use the raised hand feature in Zoom by clicking on the hand icon to join our public comment queue. Those who have joined us by phone may either dial #9 to raise their hand on Zoom or send an email to littlehoover@lhc.ca.gov, letting us know that you want to address the commission. You must provide your phone number from which you have joined the meeting so that the staff knows who to unmute. Staff will be monitoring raised hands and emails requesting comment throughout the duration of the hearing. As is usual at commission hearings, public comment is limited to 3 minutes per speaker. We are recording today's hearing, and after the hearing, staff will place a permanent link to the recording on our website and upload it to the YouTube channel. And now to the substance of today's hearing. This is the second in a series of commission hearings examining the California Environmental Quality Act, better known as CEQA. Since its creation in 1970, CEQA has been California's premier piece of environmental legislation. It has also, however, long been at the center of debate and controversy. Our first hearing provided some general framing with respect to the debate over CEQA. We listened to academic, policy, and legal experts regarding CEQA's impact, including both critics and defenders of the law. These witnesses offered different perspectives on some of the key questions in the CEQA debate. They also provided contrasting evidence regarding CEQA's effects. Today, we will hear from 3 CEQA practitioners with extensive experience in CEQA and with different viewpoints on CEQA and the CEQA process. These witnesses will discuss how CEQA works and share their perspectives on CEQA and on the current state of the CEQA process. They will also discuss whether there are aspects of CEQA that they think could be improved and what changes, if any, they would like to see. This hearing is part of a commission study designed to explore the debate that surrounds CEQA, examine its role in protecting the environment, and evaluate its impact. The commission will hold 2 additional hearings on CEQA on April 27 and May 11. I want to thank Commissioners Sidley and Aroner for serving on the subcommittee for this study and for their leadership on this crucial topic. This hearing was organized by project manager Tristan Stein. And before I ask Tristan to introduce the first witnesses, what I would share with the witnesses is commissioners are prepared for the meetings. They've reviewed the material. They are familiar with written material that was submitted. And so I would say to you, if during the course of the hearing, you find that you are being interrupted, I would ask you to take that as a compliment, because what it really means is that commissioners are invested and engaged and want to explore further your expertise and what you bring to our meeting. So Tristan, if you would be so kind as to introduce our first witness.
Thank you, Chair Nava. Our first witness today is Curtis Alling. Mr. Alling is an environmental planning expert with over 40 years of experience in California. He is a founding principal of Ascent Environmental, a statewide environmental and planning consultancy established in 2010 and headquartered in Sacramento. Mr. Alling is a leader in applying CEQA streamlining approaches that enhance the efficiency and timeliness of environmental review of programs and projects. He also served as co-chair of the 1993 Association of Environmental Professionals and American Planning Association California Chapter Joint CEQA Task Force and of the 2011 Enhanced CEQA Action Team. Mr. Alling is a certified planner as a member of the American Institute of Certified Planners since 1984, and he has served on the American Planning Association California Chapter's Legislative Review Commission for CEQA bills for 20 years. Mr. Alling, you may please begin your testimony now.
Thank you, Tristan. Can you hear me okay? Okay, great.
Yes, we can. Thank you.
Great. Thank you for the invitation to speak with you today. Good afternoon, Chair Nava and commission members. As Kristen said, my name is Curtis Alling. I'm one of the founding principals of Ascent Environmental, headquartered here in Sacramento. My perspective on this topic today is that of a CEQA practitioner. During my 40 plus years in executing CEQA requirements for cities and counties and state agencies, I've written and led many hundreds of CEQA documents of all kinds throughout the state. About a dozen of those CEQA documents have experienced litigation. My background includes advanced CEQA instruction for the Association of Environmental Professionals, the American Planning Association, California chapter, UC Davis Extension, and Continuing Legal Education International. And this includes co-chair of the 2011 Enhanced CEQA Action Team, or ECAT. This was a joint effort of AEP and the American Planning Association that prepared a legislative proposal to enhance CEQA. There is a link in the written material that I sent to you if you're interested in looking at this. It contains specific proposals for statutory changes that in many ways are still relevant today. Please know that the testimony today is my own opinion. It does not represent Ascent Environmental, AEP, or APA California chapter, my clients or colleagues. In fact, I would invite the commission to contact, if you have not already, both AEP and APA CA to hear a broader expression of practitioner viewpoints. So I'd like to make a few comments according to certain themes. The first is that CEQA, as carried out according to its original policies, offers great value for informed government decision-making, for involving the public in the review of that information, and for protecting the environment when feasible to do so. CEQA becomes the center of attention when there is a substantial delay or considerable cost increase on a project, typically driven by opposition to that project. So when an opposition includes litigation or the threat of litigation, lead agencies decide they need to take extra steps. They need to prepare expanded documents or extend the environmental review process. However, within the normal course of day-to-day business by public agencies and the review of proposed new developments, CEQA has long been a high-value source of environmental information to help the agencies make better decisions on those projects. Opposition is not the norm for the large majority of projects, and therefore, the first key theme I'd like to share is that CEQA, as carried out according to its original policies, offers this great value to good government decision-making. Second point I'd like to raise is that what I'll call regular CEQA contains powerful streamlining tools for housing and other project types that have been available for years. CEQA compliance should be as efficient and streamlined as possible, and this is particularly important for addressing the state's unmet need for housing. What I call regular CEQA procedures are those that apply generally to environmental reviews that rather than specialized processes targeted at housing. The powerful regular streamlining is available to housing projects and has been often used. The first I'll mention is Class 32 infill development categorical exemption. If a project qualifies for one of CEQA's exemptions, it should be considered first because that's often the most expedient. The Class 32 development exemption is one of the most powerful for infill housing. Class 32 has simple criteria. It's used a lot by cities and works well if the project is in city limits. Because it is limited to projects within cities, it currently excludes urbanized areas and unincorporated county territory. So one enhancement suggestion I'd make is to add urbanized county territory to the Class 32 exemption. This would substantially increase the utility of it for infill housing projects outside of cities as well as within. Another enhancement suggestion would be to pass a simpler statutory exemption for housing. As the commissioners well know, I'm sure, specialized statutory exemptions have been enacted in an attempt to streamline approvals for housing, but they have been weighed down by sometimes 20 or more complicated qualifying criteria, and therefore they're seldom used. But a simpler, cleaner statutory exemption for affordable housing with few qualifying criteria could go a long way to improving streamlined CEQA review for increasing housing supply. Another existing tool is for housing projects that are consistent with a community plan, a general plan, zoning, or specific plan, where the plan has been approved using an EIR. This greatly limits the project level environmental review, either focusing on only what is not covered in the planning decision EIR and what is peculiar to the project site, or exempted altogether. The guidelines describes this powerful streamlining, and this is the quote: CEQA mandates that projects which are consistent with the development density established by existing zoning, community plan, or general plan policies, or for which an EIR was certified, shall not require additional environmental review, except as might be necessary to examine whether there are project-specific effects that are peculiar to the site or project. For housing projects consistent with a specific plan, there's another exemption. It's in the government code for planning, not in CEQA. And to qualify, a project must be residential. It must be consistent with a specific plan for which an EIR was previously certified, and no new or substantially more severe significant impacts arise beyond what was covered in that EIR. The
Mr. Haley?
validity and yes, sir.
I'm sorry. This is one of those instances I have to interrupt you. I have a,
Okay, I'll consider it a compliment.
thank you. Commissioner Sidley has her hand up.
Yes, I do. Thank you. And thank you, sir, for your testimony. I appreciate it very much. I just would like you to comment a little bit through your experience and your numerous years working with CEQA. Have you seen a trend of late where the documents are more complicated, thicker, and more expensive? Is that a trend that you're seeing?
I think what my response to that would be that where there is opposition to a project, so that, and in particular, if there's a threat of litigation as a result of that opposition, then the answer is yes, that lead agencies have sought to bolster environmental documents. It makes them larger, more explanation, and extend the processes to do that. As far as a general trend across all documents, I don't think I've necessarily seen a broad trend that affects everything. There's some environmental documents that are very, very slim and streamlined, and many of those are still being used. But certainly where there is controversy and potential opposition, and particularly where there's potential for litigation, then that has increased the size of documents.
And your experience, those projects that are seeing more extensive work done in CEQA, industrial type projects, infrastructure projects of that sort, infill housing, low income housing, things like that?
It could be many different kinds of projects depending on the source of the controversy. It certainly could be an infrastructure project that is involving impacts to sensitive resources. Environmental organizations may seek to scrutinize those. It could involve projects that neighbors are concerned about, whether it's a commercial, multifamily housing or industrial project, to try to impede the approval of that project. I have a comment later about that phenomenon, or could be opposed by organizations with an economic interest, and that could address any number of types. So I don't know if it's a type of project that this happens to more than others, but it can be any particular kind depending on whether there's controversy.
Okay, thank you.
Certainly, anytime. Okay, what I wanted to mention next, as far as exemption that is applied to housing, is the exemption in the government code for projects consistent with a specific plan. This is essentially a complete exemption if the project qualifies as a residential project consistent with a specific plan that had an EIR, and nothing new in the way of significant impacts comes up. What's important about this exemption is that its validity has been confirmed in court. One example is a 2013 decision for a residential project that was within a BART transit center specific plan in Dublin and concerned Dublin citizens versus the city of Dublin. That project was upheld. A similar streamlining opportunity is offered for housing projects that are consistent with a certified program EIR. A program EIR that covers a large plan for housing development that may be implemented with a series of later projects can create substantial streamlining for those later projects using a within the scope finding with the program EIR. Essentially, the project is consistent with the analysis in that program EIR. In that case, they can be approved without preparation or public review of another environmental document. As a practical matter, CEQA review for housing projects within the scope of a program EIR can be reduced to a few months. Although this example that I'm going to share is a non-housing application, the strategy is currently working for a statewide vegetation treatment program, the California Vegetation Treatment Program, or CalVTP, for wildfire risk reduction. That program EIR covers 20 million acres of California's landscape and employs a special checklist to provide the evidence that a later treatment project is within the scope of that EIR. And since 2020, it has supported approval of thousands of acres of treatment over 40 projects around the state, and probably 40 more that are currently in process. So this approach can be equally powerfully applied to affordable housing or infill projects where a city or county, or maybe a metropolitan region, has some form of housing implementation program covered by a program EIR. So the point I'm trying to convey is that regular CEQA already offers several good streamlining choices for housing projects. In my opinion, those tools are not used as widely as they could be, which may be another enhancement action that could be taken, where the state could substantially expand state-funded training or technical assistance to cities and counties. Third point I'd like to make is this gets to the question that was raised to a degree, at least my response to it, that a key obstacle to timely government decision-making on housing projects is misuse of CEQA litigation to obstruct project review. Litigation is a powerful feature of CEQA, and it's used by the public and organizations to hold government agencies accountable for following CEQA's requirements. And when a lawsuit is filed with the purpose of achieving environmental protection or the information required by CEQA, that can have merit. But if it's filed for other purposes, such as delay or obstruct to achieve an economic interest or a social goal, then the lawsuit becomes a misuse of CEQA litigation. An all too common disruption of the CEQA process related to this litigation situation is late submittal of information. Causes of litigation for a future lawsuit may be brought up late in the CEQA process, even after public review periods or after completion of the CEQA documents. This is because the Public Resources Code allows this to occur with the provision that alleged grounds, this is the quote, alleged grounds for non-compliance with CEQA were presented to the public agency prior to the close of the public hearing on the projects. That can be the last public hearing. And because housing projects are land use decisions, typically there's a public hearing on their merits, and that's after the CEQA decision is made. And opponents have withheld CEQA allegations until the last hearing after CEQA has been completed and submitted volumes of comment materials at this late stage. And this disruptive late submittal strategy has been called a data dump. The enhancement suggestion would be to provide a second public circulation period after the original one for an EIR, or proposed initial study negative declaration, that gives the public an opportunity to review responses to comments they made on the first one and object as a part of the final steps of environmental review process at that second review time, but then in return prohibit litigation causes from being raised after that, like in the last public hearing. This is similar to an objection period step that's used by federal agencies to end the NEPA process, which is the analogous federal process to California's CEQA process. A statute amendment would be needed, but if that was possible to do, the last public hearing on a project would no longer be available for this targeted late arriving comments. Litigation that's meant to obstruct is allowable under current law, and this is an issue that needs attention. Rather than a lawsuit meant to hold government accountable for environmental protection or environmentally informed decisions, litigation can be filed when it's actually driven by other underlying interests such as economic gain or social concerns. And as I've said before, this is a misuse of litigation. There are examples of CEQA lawsuits that are meant to obstruct repeatedly reported. You can search the term misuse of CEQA and come up with lots of stories. This isn't CEQA's purpose. Changes to litigation process are warranted. So as far as enhancement suggestions here, I'm an environmental planner, and we experience this. It happens on our projects, but it's really the environmental attorneys who are best equipped to determine how to address this. There are complexities and trade-offs in changing the litigation process, but if it can be approved, it will make substantially beneficial difference by refocusing environmental review on the purpose it was made to be for, and that's how to help the lead agencies reach a better project decision rather than girding for it. My final point I'd like to make is that there was a Supreme Court case in 2015 that eliminated the protection that housing project residents had for decades in CEQA documents, where it was standard evaluation to examine whether future project occupants of a housing project would be exposed to existing environmental hazards. This had been standard practice since the late 1970s and early 1980s, and I can say that because I was there. And EIRs routinely address this exposure to things like slope instabilities, flooding, wildfire risk, soil and water contamination, hotspots of toxic air contaminants, and existing excessive noise. In 2015, in the decision by the Supreme Court, California Building Association versus Bay Area Air Quality Management District, the Supreme Court held that, and this is the quote, that ordinary CEQA analysis concerned with a project's impact on the environment rather than the environment's impact on a project and its users or residents. And this decision constrained CEQA review of whether the future residents of proposed housing projects would be exposed to environmental hazards, and leaves those future residents vulnerable to those existing hazards without that information being factored into a project's decision. Examples are housing in a very high fire hazard zone, serving disadvantaged communities near an industrial contamination site, in harm's way of sea level rise, or close to a freeway that's exposed to substantial toxic diesel emissions. The importance of this topic for the housing crisis is for achieving quality in the environmental information required for a housing project review. If a proposed residential project would add dwelling units near existing environmental hazard, exposing those residents to that substantial hazard, and not be a part of the information that city or county uses to approve the project, is that really helping resolve the housing crisis? So the enhancement would be to restore that exposure to existing environmental hazards as a CEQA impact. It would need a statute amendment. It wouldn't be a difficult one to make. The statute defines environment in terms of the physical conditions that exist within an area. An amendment could clarify that human beings are part of that physical condition, or there could be a phrase added to the statute definition of significant effect on the environment that says, including substantial adverse change in exposure of human beings to an existing environmental hazard. Some may feel this would expand CEQA's purview, but in reality, it would just return it to the standard practice for environmental analysis that was in place before 2015, and it would help protect those residents of future housing projects located in a setting where there might be a potential hazard. Thank you very much for my chance to share these thoughts with you, Chair Nava, and that completes my testimony.
Thank you. And there's Commissioner Hernandez.
Thank you. I must admit, in the last 36 hours, I read more about CEQA than I thought I ever would. But I'm a numbers kind of guy. And so 2 questions. One, given your experience, I mean, right now, how do you collect data and information? I mean, what is out there to be able to kind of ascertain kind of what happens? And then 2, knowing that there is no structured way of collecting data, what would you recommend is the best way, most efficient way to start maybe collecting additional information on the process?
And Commissioner Hernandez, if I could be sure I understand, so you're looking for data on how CEQA is applied around the state, or?
The information in terms of the number of cases, in terms of how many cases are prolonged, I mean, how many cases are successful in terms of there's actual immediate impact on the environment. I mean, a way to start measuring the impact of CEQA or measuring the number of delays of CEQA.
Mm-hmm. Well, and I think you've probably, I think the studies were referred to in the first hearing. There have been studies conducted about the impact of litigation by different parties, and they have come to sometimes different conclusions. And so they've been conducted by law firms or economic consultant. I know those are two. And so they provide, they did their own original research by survey to cities and counties to come up with that information. I think that's probably the way that it would need to occur if you wanted to do it on a more, I guess, government-sponsored approach. The Office of Planning and Research does an annual survey of cities and counties, and that information has proved very valuable over the years. And that certainly could be continued or expanded through that office to consult and gather that information. That's probably the best way I can think of offhand to do it, would be through the Office of Planning and Research. But of course, that's a funding and staffing issue that comes up to enable them to do that.
Thank you.
Thank you. I saw Commissioner Sidley had her hand up. She took it down. Okay, never mind. Let's turn to the other commissioners. Any questions or comments with respect to Mr. Ailing's presentation? I don't see any. Let me express my gratitude. I think part of what is so helpful with respect to the material that you submitted is a very concise description of the topic that you wanted to address, followed by enhancement suggestions. So we don't always see this kind of presentation, but you have put it in a manner that's really easy to access, and that I am sure will be of great assistance to staff and the commission as we formulate our recommendations. So let me express my gratitude to you for taking the time to share your experience and expertise with us.
I appreciate that, sir.
Thank you. Tristan, I think that we're ready for another witness.
Thank you, Chair Nava. Our next witness today is Tina Thomas. Ms. Thomas is an environmental law and land use attorney with the Downey brand law firm. Before joining Downey brand, Ms. Thomas founded the Thomas Law Group in 2010 after 28 years with Remy Thomas Moose in Manly. Her practice is focused on environmental and entitlement processes, representing property owners, developers, builders, governmental agencies, trade associations, and environmental organizations. At the core of Ms. Thomas's efforts is an unwavering commitment to finding solutions that are both economically and environmentally efficient. Among other accolades, the Sacramento Bar Association named Ms. Thomas a distinguished attorney in 2005. Ms. Thomas was also one of the original authors of the Guide to the California Environmental Quality Act and assisted then Senate Pro Tem Darrell Steinberg with the drafting of Senate Bills 375 and 743. Ms. Thomas, you may please begin your testimony now.
Ms. Thomas, I believe your audio is off and you're muted and your video is off. Ashley, can we confirm that is on her end? There we are.
There we go. I'm sorry. This is the part about, coming over to a new firm. Things are all different, and I apologize for that. So I wanted to say thank you to Tristan and thank you to the chair and members of the commission for conducting this research. It's very important. It affects so many things in California, economic growth and housing. And I just think it's an important topic to analyze. I'm going to take a little bit of a different tack than Curtis because I actually litigate these things all the time and have for 44 years and counting. So I recognize that there are streamlining measures that the legislature has adopted, but there's always the chance of litigation, no matter what you do and no matter how you streamline, no matter what mechanism you use, you are exposed to litigation, and all it takes is the filing of a lawsuit to essentially create a de facto injunction and not allow that project to proceed. So I want to focus on the litigation aspect of it. There's no doubt in my mind that when CEQA was adopted in the 1970s and passed by the legislature, signed by the governor, that it was done for very noble purposes. And even the first case that addressed CEQA, the Mono Lake case, it was about that noble purpose, and it looked at all those reasons for protecting the environment and why the environment should be so important in any decision that's made by a local or state government. But unfortunately, over the decades, it's been hijacked by a number of different entities for not so noble purposes. So NIMBYs for preserving views, for essentially drawing up the drawbridge and saying no more people in this community. That happens quite a bit. We also have the unfortunate situation, and I hope I'm not stepping on any toes here, but where unions are using CEQA to attempt to get project labor agreements, and then if they do not receive a project labor agreement, litigating those projects. And then also this unfortunate situation of competitors suing competitors. So you have grocery stores versus grocery stores, gyms versus gyms, nut processing facilities versus nut processing facilities, and the list goes on. So there's all these different abuses that are currently occurring. So I want to look at a couple of the cases that talk about this, because I think the justices over the past year have really focused on this potential abuse. And I think it's worthwhile for all of us to pay attention to what the courts are saying, because it's taking up a lot of their time. These cases are big, they involve large records, and they take an immense amount of time and energy. And it almost always result in a very lengthy opinion that is well researched. So here's an example that I wanted to look at. This is a case in the city of Los Angeles brought by the Carpenters Union against a 600 plus housing project in an area that really deserved redevelopment. It was an abandoned Montgomery Ward building that was fortunately served by very good bus service, but was litigated by the Carpenters Union because they did not receive the PLA that they requested. And so there was a lot of pressure throughout the administrative process before the agency. As Curtis mentioned, these lengthy records or lengthy letters submitted on the last day, right prior to the hearing, that are impossible to respond to. So you have to continue hearings, that kind of thing, just continue it throughout the administrative process. And in LA, there are a number of different levels that you have to go through. And in the end, they filed a petition for writ of mandate. There was a trial court ruling that was unfortunately way off base, and then an appeal. And unfortunately, the Attorney General joined in on the appeal on behalf of the unions. So we have a housing project. We need housing in this state. And you have the Attorney General opposing a 600 unit housing project. It really made little sense. The Court of Appeal reversed. The applicant prevailed, but he'd lost so much time. He barely had his financing in place because, again, just the filing of the litigation is a de facto injunction on your financing. You can't go to the bank. You can't go to get a tax credit financing project completed. So the 3 years, or excuse me, the 5.5 years from application to when the appeal was finally resolved, 5.5 years, they were in a difficult position. Their financing had substantially changed, and what they did was they filed a RICO lawsuit against the labor union. So that's that action is moving along in the federal courts. But what this does is that it illustrates the amount of time these cases take when they are filed and what the effect on the applicant is during that period of time. So I think it raises a lot of questions that I'm hoping that your commission will address. And again, I mentioned that there has been this focus by the judiciary in 2022 on cases and the fact that they have been very difficult on housing projects. There's a case in Tiburon where the application was filed in 2007 and it was finally resolved last year. So 16 years later for roughly 60 units in Tiburon. Now, it's Tiburon, there's going to be opposition, that's obvious, but really for something to take 16 years is amazing. And if you're going to read any case, I know that you've read a lot of material on CEQA, but if you're going to read any case in this one's worthwhile reading because at the end, the judge draws a lot of conclusions that I think are fascinating, that something is definitely wrong with this picture. And that it's no wonder that developers often throw in the towel. So, I mean, I think there's some great observations in this case, and it's worth reading if you have the time to do so. More recently, there was a case where the petitioner's lawyer was basically told by the court that there was a damages action against them because they had proceeded with the case, even though it was utterly without merit and the attorney had actually miscited facts throughout the administrative process and throughout the hearings. So the petitioner's attorney is going to be subject to the damages by the petitioner for bringing actions against a single family dwelling in San Anselmo. In Livermore, there's a case where 130 affordable units, it was a tax credit project there because of the filing of the litigation, their loan system, their loan ability under the tax credit program was in jeopardy. And so they sought a bond from the court, and the court allowed them to get a bond because the court observed that it was clearly brought for the purpose of delay. So I think it's really interesting that you're starting to see this trend in the judiciary about delay and what the effect of delay is on the applicants. As Mr. Alling noted, there are some things that have been done in the legislature, such as the infill exemption, tiering, those types of things. But there's always that threshold question of, even if you choose 32 class 32 exemption, you're going to get a challenge. You have the possibility of getting a challenge from a neighbor or a labor union because it doesn't apply. So there's always that threshold question of, is it actually applicable? So I have a couple.
Ms. Thomas, right before you launch into that, let me turn to my commissioners because you did prompt some questions. I saw Commissioner Hernandez had his hand up, followed by Commissioner Sidley.
Thank you, Chairman. Two quick questions. The first one, in the 16-year case, was it the same presiding judge over those 16 years?
It went between the federal court and the state court, and I believe that there were some back and forth. I mean, that's one of the problems, obviously, Commissioner, is that courts change, judges change. And in fact, there's a provision in CEQA that requires that you have CEQA judges in certain size counties. That's a great idea. But those judges change. They rotate every year.
And the second question, it sounds like you've been all over the state on this. And so, I mean, in your experience, I mean, you've seen the difference in expertise in terms of the judges by county. Is that correct?
That's correct.
And so one thing that, I mean, if you can opine on, I mean, one thing I was reading about is the whole notion of having a CEQA court. Is that something? Okay. So maybe
I've often been an ardent supporter of a CEQA court, but the judiciary is not fond of that for a number of reasons, because then they'll say, well, why not, a defined criminal court, or why not this? I mean, why this subject only? My personal opinion is that if housing is so important, we're going to have to do something that ruffles feathers. So I think that's a really good point. And yes, there is a difference there's an obvious difference between counties, but not only that, you're talking about judges who have to deal with, something related to child welfare, and then they're popping over to a criminal case. And then they've got, a 30,000 page record on CEQA. So it's very complicated for these judges. It's
Thank
a tough statute.
And let me turn to Commissioner Sidley.
So, Ms. Thomas, thank you very much for your testimony today. I'd love for you to comment on a couple points that you may get to as you're still testifying, sort of building off what Curtis had talked about. He did talk about doing, a master plan and then tiering off. For those who aren't CEQA practitioners, you can then use the work that's been done, and you can apply that back to a new study. What he didn't mention, and I'm curious of your thoughts, is how long it takes to do a general plan EIR, whether or not those are challenged more often because of the breadth of that type of a document. Also, very interested in your thoughts as you're talking about the labor unions and others, next door neighbors, your thoughts about standing and also piercing standing. A lot of times, somebody who may have an economic interest is going to call themselves citizens for a safe environment, as
Correct.
opposed to who they actually are. So I would also be very interested in hearing your thoughts about standing. Thank you.
So on the first question, yes, obviously it does take a long time to do an EIR on a housing project that's, for a broad geography. So I'll just take one that I know of that I worked on, for a number of applicants, and that was a specific plan in the city of Sacramento. And I have to say it's been extremely helpful. We've been able to move projects really quickly, but there are some hurdles in that project that it exempts, for example, that wouldn't apply to a project for where there is an alleged historic structure. So you always have that threshold argument of, is this structure that we want to take down to build new apartments historic? So you always have that threshold issue. So it has helped in areas where there's vacant lots, but it hasn't helped in areas where there's actually something that, particularly in Sacramento, where you need to tear down a building that's, over 50 years old. So there are complications related to that process. In terms of the solutions, my first suggestion has to do with standing. So you're reading my mind somewhat. There should be no anonymity at all. It shouldn't be a label. It should be who is actually involved in that litigation. I think the defendants, the real parties and interests, the agencies, the applicants all have the right to know who that person is or those persons are, and not hide behind a name. So I believe that is something that would possibly limit litigation, because people would not want to have their names out there and be exposed to, some kind of retaliatory action, like the situation in the Susan Brandt Hawley case that I mentioned, the Jenkins case. The second thing is, petitioners have no skin in the game. They can go through litigation without any impact to their pocketbooks. So there has to be something where they have an incentive to settle. And right now there's no incentive to settle, because they can go all the way through the trial court process, 2 years, all the way through the appellate court process, another 2 years, and through the Supreme Court petition for review, maybe, 3/4 of a year, without having any financial exposure. So I think there needs to be some thought, some creativity on how to put some sort of financial penalties in place when petitioners don't prevail, particularly where our courts find they're utterly meritless, as in the Livermore case and in the San Anselmo case. So I think that there's got to be some sort of thought into what kind of incentive, how do we get to an incentive to settle? Remedies. Remedies is an important part of this because when you get to the point where the court is issuing a remedy, if you have the situation, which is not unusual, I'm just going to use the Sacramento case where it was for 350 units in Sacramento. There were 28 claims against the project under CEQA. They prevailed on one minor point, and that was whether or not the threshold of significance for traffic about 3 miles away was adequate. But that sounds minor and that you should be able to fix it quickly, but what it requires is for you to rescind the EIR as a general rule, rescind the entitlements or vacate the entitlements and start over again, and then to go through the litigation process again. So in that particular case, they had to fix that one threshold. It took them 2 years to get to a document that they could then go back to the court with and say, we're through all the process. So there has to be something related to remedies that fixes that issue of remedies. I would propose something along the lines of interlocutory remands, where you can go straight back to the court and not have to go through the process of 2 years between, starting at the planning commission again.
And just if I might add, Ms. Thomas,
Sure.
For the rest of the commissioners, you could pick up a new petitioner as you start the process again. So even though you want to think it's res judicata, you want to think that it's actually been done, that doesn't actually work in these particular situations, because you're presenting what is considered by this process a new presentation, and you can pick up a new petitioner and you literally do start again all over with the same potential time frame that Ms. Thomas has pointed out. So I just wanted to share that.
That's actually, you can pick up new petitioners and you can pick up new claims. So you're just exposing yourself to kind of a constant wheel of litigation. Expediting the litigation process. I mean, again, if it takes 5.5 years from the time you submit your application to the time you get a final judgment, you're likely to lose your funding, your financing, or it's going to change dramatically. I mean, you can just see that from the last year and the mortgage rates. The legislature has expedited a lot of the large projects, the Oakland A's project, the Sacramento Kings, the Warriors, all of those has been expedited. They've been done in, a very short period of time. They're billion-dollar projects with a labor contract that are 100% green. That's great. But why not extend it to all housing projects? And I don't think we should just carve out affordable, because we need all levels of housing in this state. So I would suggest that there's some sort of way to expedite housing. Perhaps it is that housing or that court that, just addresses housing projects with judges who know the law and can process these things really quickly. Expedite the record preparation. This is the one thing that the petitioners use as a way to really extend the litigation and to get to that sort of prevailing by attrition that the courts have recognized throughout. So ways to expedite the record. To me, once the agency has prepared the record, it is there should be a presumption that it's adequate, and not having to go through depositions and discovery to determine whether or not it's complete. So I think once the agency has certified the record, that there should be some weight to that determination. So I think those are my suggestions right at the outset. I've put together lots of, different bills for expediting CEQA. It's something that, comes up every few years. Unfortunately, it generally dies somewhere within the legislature with some kind of a Band-Aid that doesn't work very well. So if people are gonna make a change in CEQA, it has to be big, it has to be bold, it has to be expected to offend some people. I mean, we've got to break some eggs if we're gonna do this.
Vice Chair Varner.
Thank you, Ms. Thomas. Is it possible for you to share with us those bills, those proposed bills that you mentioned? It'd be interesting to see the breadth of those and what's in there, as opposed to some of the other things that that I believe we're going to hear from Mr. Carstens here in the
I'd be
next-
happy to. I have to go back to my old firm and go through that. So there'll be a little bit of a time lapse, but I'll get them to you as quickly as possible. I'll get them to Tristan as quickly as I can.
Thank you very much.
Yep, thank you. Turning to commissioners, seeing no further hands raised or questions or comments. I want to thank you very much, Ms. Thomas, for your testimony. And I'm sure staff and the rest of us will be looking forward to the legislative concepts that you had put forward before. Thank you.
Thank you very much.
Commissioner Sidley again?
Yeah, just quickly, Ms. Thomas, before you drop, the latest case going on at UC Berkeley.
Yes.
And where the court has said that the students might be the impact.
Correct.
Is that not actually the position that, I don't know if you heard Curtis's testimony, where he was talking about how, not how the project impacts the environment, but how the environment impacts the project. Is that not what he's talking about? And that's the outcome, is like students then are the problem?
Well, as I understand the language in that case, what the court is saying is that students partying and going, just partying at night, that they make a lot of noise, and that in and of itself is an impact on the environment. So, but it's a new environmental impact that we hadn't examined before. And so again, things keep changing, and this comes out of the same district that had all the reprimands in the Tiburon case. So you often don't know kind of what direction you're going in.
Right. Also, when you've discussed the time frame, and if a court does find a minor problem, and then you go back and you are told to redo some of the work that you did previously. I also, if new models come out, would the new models require you to go back and do things that at one point were found to be correct, and then you have to redo those as well because time has lapsed? Is that still an open question in the courts? Is there anything that what would you think about freezing a timeline for models, giving it 3 years, 5 years of a timeline from the day you issue an NOP or something of that nature as a potential change?
Yeah, I mean, things change throughout a record process or a process of an approval all the time. So just for example, housing projects up in Northern California, during those, there was quite a few of them going through the process when they designated high hazard fire zones. Do you have to start over? Well, I mean, if you're going to be prudent, yeah, you're probably going to go back and look at that. And I think it relates the same thing to models. The problem is things constantly change. So if you could, I mean, I think that the answer is there may be an answer about freezing models, freezing situations, but I think it's just also getting through these processes more quickly.
Understood. Thank you for your thoughts. I appreciate it very much.
Sure. I'm happy to have testified. Thank you.
Thank you, Ms. Thomas. Tristan?
Sorry about that, and thank you, Chair Nava. Our third and final witness today is Doug Carstens. Mr. Carstens is the managing partner of Carstens, Black and Minteer, a law firm that practices environmental and land use law throughout the state. He graduated from Cornell University, served as an officer in the United States Navy for 5 years, and then attended law school at UCLA. Mr. Carstens' law firm has represented petitioners who enforced environmental laws to protect people against proposed oil drilling, preserved important historic and cultural resources, and promoted affordable housing. His firm's work has resulted in modifications to sprawl development projects, the reduction of greenhouse gas emissions, and the creation of urban parks for communities of color. Mr. Carstens has written various articles about environmental law and co-chaired over a dozen annual CEQA seminars through Law Seminars International. He is a past president of the Sierra Nevada Alliance and is currently the president of the board of the Planning and Conservation League. Mr. Carstens, you may please begin your testimony now.
Yeah, Mr. Carstens, as soon as you log on.
Yeah.
so we can see you.
I believe he was, Mr. Chairman, in the meeting, and then
Okay.
I'm told that he left, and I believe he's now back.
All right, if you hang on, Mr. Carstens, only because I've got a note here that says that Mr. Alling had raised his hand before. So Doug, if you could just hold on a minute. We can.
Ashley, Ashley, in that case, if you can go ahead and promote Mr. Alling back so that he can speak.
Yeah, I'd hate to lose the opportunity for a witness to contribute if they're still here. Here he is, Curtis Alling. There you are. We can see you and
Okay.
hear you.
Thank you. Thank you for bringing me back, and I apologize for inserting myself in, but I just wanted to clarify regarding Commissioner Sidley's question about the Berkeley student noise situation, and I think it was answered well that that's not what I was referring to when I mentioned exposure to existing hazards. Existing hazards are like if a housing, in the case of housing, if housing is proposed within a high fire hazard zone, exposure to that existing wildfire risk has been excluded as a CEQA impact unless there's an exception, unless the addition of the subdivision or the housing would make it worse, exacerbate that hazard. But in the case of the noise impact, that is the noise being caused by the residents of the new project. I would say, just as a comment on that I've seen a legislation that proposes exempting unamplified human voices from being a CEQA impact, which might be a very good idea. So anyway, thank you for the chance to interject.
Yeah, I figured it was something that you wanted to bring back in, otherwise you wouldn't have.
Just wanted to clarify that one point.
All right, appreciate it. Thank you very much. Mr. Carstens, if you would be up, we can see you and you're unmuted.
Well, thank you, Chair Nava, honorable commissioners. Good afternoon. I am really pleased and honored to be here and this opportunity to present the testimony this afternoon. All of my views are my own. I want to clarify that, not speaking on behalf of anybody, but I think that's been the disclaimer of everybody. I did submit a statement, pretty detailed, 14 headings and 72 footnotes. I'm not going to read all that. I just want to recognize that I really appreciate the work of the commission and wanted to provide material as possible to assist with the efforts of this very, very serious and deliberate endeavor. Before talking about some of the points about CEQA, I wanted to at least provide just a little bit of information about my background in addition to what you have there in the biographical material, because this does, I believe, affect who we are today is who we've been. My family, half my family tree has roots in the Republic of the Philippines. I had a great grandfather who fought the Spanish, who colonized the Philippines until the 1800s. So our family knows something about fighting the colonizers and protecting the people and the places that we love. I had one grandfather who's from Lebanon, and he served in the U.S. Army. He was a doctor stationed in the Philippines before World War I. And my other grandfather was also in the U.S. Army. He was a doughboy fighting in World War I. So we value multiculturalism and service to our country and the greater good. I myself was in the Navy. I think the bio mentioned that. I was stationed on a ship operating out of the port of Long Beach, the Long Beach Naval Shipyard. I want to recognize, the goods movement in this country is a very necessary part of our economy. Part of the Navy's mission was to defend the freedom of commerce and the seas. So I do know about swearing to uphold and defend the Constitution and enforce laws to protect against those who would seek to violate or act against them. So right to CEQA. CEQA is like a constitution. And indeed, Senator Byron Scheer called CEQA a Bill of Rights for environmental democracy. This law, which has been in place for over 50 years, empowers people. I think you heard a lot about that at the first hearings. It protects the air we breathe, the water we drink, and the people and places we love. Assemblymember Marit Suchi recognized CEQA as providing civil rights to protect brown and Black communities, among others. So it's hugely important. It serves the twin goals of ensuring public participation, which is democracy, and protecting the environment. These two goals, we believe, provides the lens through which proposed CEQA changes should be examined. They could either assist these goals or they could detract from them. On your first day of hearings, you heard a lot of doom and gloom, even claims that the legal system is somehow dystopian. I'm here to tell you, California is not a parody of a functioning democracy, nor is its legal system. While there's always ways to improve the law and make things better, and we can talk about some, I look forward to that, CEQA is not creating the crisis that it was made out to be. The effects of CEQA should be understood as an organic whole, not just in the bits and pieces, based on a few stakeholders' narrowly focused personal experiences. Here is one footnote I thought might be entertaining, which was the Indian folktale of the tale of the 6 blind men and the elephant. I'm not going to retell it, but I commend it to your attention because it emphasizes the importance of personal experience, but then integrating that with other people's experiences. And while doing that, of course, maintaining civility. And I think civility in the process is always very necessary. And I do appreciate being in such esteemed company. I mean, the author of the guide on CEQA, Ms. Thomas and Curtis Alling, the reasonableness of, some of the things I'd like to state a lot of agreement in some of those. But before getting to that, I'd like to just touch on how CEQA works. I think you did hear a lot of that at your first hearing. And because I thought it may assist, I attached a flow chart of the CEQA administrative review process to my comments. And I don't plan to go over that whole flow chart, but I just wanted to emphasize that the administrative review process under CEQA is like the sunken part of the iceberg. The litigation is the tip of the iceberg, but you've got the whole iceberg, which is the CEQA review process. And the sunken part, the 98% part, goes on outside of the courts. It goes on in the administrative agencies, and litigation really represents only about 2% of all of those kinds of approvals, maybe even less than that. There's only been an average of 195 cases. I believe Commissioner Hernandez, you asked about what the numbers are. There's very good numbers that have been put together, and I did put a link to the report on that. It's in footnote 26 of my written remarks. I actually cited it in all kinds of places. The Rose Foundation report, CEQA, California's Living Environmental Law, CEQA's Role in Housing, Environmental Justice, and Climate Change, 2021. That established that there's only 195, an average of 195 per year CEQA cases for the past 20 years. And that number has not varied. It's been about that, more or less for the past 20 years. So there's not some, sharp uptick or changes in those. And it's very verifiable. All of the CEQA petitions are sent to the Attorney General, so it's easy to count them and to understand exactly who's filing them and exactly what they're about. So CEQA being a process that encompasses both administrative review and litigation, tip of the iceberg is the litigation, but that is, of course, a lot of the focus. CEQA does not dictate approval or denials of projects. It takes a judge's order to stop a project, and that only occurs where the law has been violated in a substantial and prejudicial way, when the agency has deprived the public or other agencies of vital information. Judges are smart. I want to endorse and remind everybody that we've got a judiciary that is full of very knowledgeable people doing their level best to call the balls and strikes. And they, they're doing the best they can with it. And they have a lot of discretion to craft remedies to the violations they find. Under 21168.9 in the Public Resources Code, there are ways that they can craft remedies to suit the particular findings of illegalities that may have occurred. So CEQA is not the boogeyman standing in the way of development, nor should it be scapegoated as such. It provides a clear and orderly process, and the judiciary is very deferential to public agencies in the CEQA process. Petitioners bear a heavy burden to show any violations of the law. There's no state agency that enforces CEQA. It's generally enforced through citizen suits, and you don't have to be a citizen to enforce. It's just called a citizen suit, but public agencies and the Attorney General will also bring CEQA actions. I mentioned how rare these are, 195 per year. Moving right along, because I would like to get to our recommendations. I mean, I had highlighted 3, but there's a whole set that I also talk about. I really should strike that word "are" because I'm here in my individual capacity. I'm not talking as president of PCL, even though PCL did a whole process about this. I'll get to. So CEQA is a safety net. It's a backstop when other laws and mechanisms fail people. I think the chair had mentioned the OES. It's sort of like a go-to statute. It just fills in and everything is tasked to it because of how well it's done its job in various places. It's been used by communities at all income levels, environmental groups, local governments and special districts, unions, businesses, environmental justice groups, historic preservation groups, individuals, Native American tribes. California is a big state. It has a lot of interests and rightfully and thankfully so. So I wanted to note at the last commission hearing, every public comment, every single one was supportive of a strong CEQA. I think that's hugely important. CEQA has been a powerful tool to advance environmental justice and combat climate change and its effects like wildfires, water allocation. Some of California's most complex problems these days, CEQA can help address and has been helping to address. I would really like to urge you to watch this film. I have a 1-minute clip, but there's another film called Boxed In, CEQA Protecting Public Health in South Fresno. It's about 8 minutes, but it's a really great film, and I put it in a footnote to our statement. But the voices of actual community members, not just their representatives, not just people like me or some of the panelists you heard last hearing, the actual community members should be heard. And I'd like to ask if staff might have it queued up to just play a 1-minute video from Juan Flores. I really thank you. That's I see the screen shifting already. Please go ahead. If it's on cue. And it looked like it was there, and I also could do a screen share, but
It's back on.
Thank you. It's just 1 minute.
Laws and democracy in America are being fought by industries, just like the oil industry, who are trying to bring down protective laws like CEQA that have empowered our communities, that have given them the tools to raise up, to go up to the court, to go up to their city council and say, wait a minute, not that easy. Your job is to protect us, not to protect the benefits of an industry, but to protect the people that live within the city boundaries. And here's CEQA, and CEQA is giving us this power. You take that away from the communities, especially low-income communities, communities of color of California, and you take their power. You take their American dream. And not only the American dream of these communities, but the American dream of the nation as a whole.
Thank you. I appreciate playing that video. I mean, you take their power, you take their dreams. That's what CEQA is about, is empowering people. And it does affect that dynamic. We've, in our office, represented people like Juan's group. We've represented the Communities for a Better Environment about an oil refinery in Wilmington, largest on the West Coast. We've represented the Center for Biological Diversity, and Aruna Prabhala described a lot of the cases at the last hearing. We've represented Sierra Club and League of Women Voters, interested in a project in Fresno County, a sprawl development. We've represented communities around Wilmington, San Pedro, but we also helped achieve settlements there. I think very significant settlements, very beneficial and forward-looking settlements, along with the city of Los Angeles and the Port of LA. So I think one of the highlights I would like to emphasize is there are ways to work together. There are ways that people can come together from their different perspectives and achieve real protections and win-win-win solutions. I mean, one of the favorite ones I think just mentioned briefly in my biographical material was we had helped a community in Los Angeles facing a warehouse proposal in north of Chinatown. And when the community organized and got together, Eventually, that ended up being converted into a state historic park, the State Historic Park of Los Angeles. And it was a win-win-win solution because the developer got return, the city achieved a mutual win, the community was able to be served. And there's a lot of examples of that. I mean, I could also give examples of negotiated settlements where communities have sat down with developers and there's attorneys and worked out solutions. And part of what the CEQA process does is give people the opportunity to do that, to express their concerns, to be heard, and to work things out. That's the 98%, again, of that iceberg under the water. And then there's the 2% that maybe people have to litigate. There's still solutions that can occur there. I'm at my 10-minute mark. I know there's other parts about the allocation of water. There's a whole discussion we have in the statement about other laws not really filling the void, but the legislative changes that we've, when I say we, I really have to strike that word from my mouth. I was part of a process at Planning and Conservation League called CEQA Modernization or 2.0 that worked on a lot of what the commissioners have been asking about, certain solutions about, can we do this or can we do that? We worked on a lot of that and like to describe it, but I also see a hand, so I'm just gonna, thank you.
I'm gonna make you the chair for this part of the presentation, but I see Commissioner Cannella.
Yeah, thank you, Mr. Chairman. So, you know, I certainly appreciate and value when neighbors get together or the community gets together to express concerns, and they use the CEQA as the method to do that. I think that's important, and I don't think that should ever change. But has there been any studies, you referenced how many go into litigation. Has anybody looked at how many CEQA challenges, either, you know, through litigation or, you know, by holding the project up or whatever, have been done by competitors or been done by labor to get project labor agreements? Because I think those are the concerns and the areas that we would like to look at, right? So if it's legitimate issues, that's one thing, but if it's a way to delay a competitor or to get something out of a project, I think that's an abuse personally that we need to try to figure out how we can deal with so that projects aren't held up forever. So have there been any studies done to look at those types of CEQA challenges?
I do understand the concern, and I think there are studies and there are studies in the work. And one of the reasons that these studies are possible is, as I referred to earlier, every petition, every CEQA petition is sent to the Attorney General by law. It's in the CEQA statute. And so it's possible to look at the names and who's filing them and why, to understand there are certain labor organizations that have filed. It's actually a small component of the overall constellation of CEQA cases. And there are businesses that have filed. It's a little bit difficult to say if they're competitors or not. Sometimes people are in the same field and they want to ensure there's a level playing field, because when people skirt laws, they do gain a competitive advantage by not having to comply or spend money. So there are businesses and labor unions who have done great work in protecting the environment. A lot of the labor union cases involve refineries where pollution is rampant or public health and safety is at risk. And some of those cases have benefited everybody in the efforts that they have made to ensure compliance and environmental protection. So to answer the question again, it was a pretty long answer, but there are studies, there's probably more on the way, and there are ways to get at that question of exactly how many is that compared to all the other that's going on.
It sounded like with your answer that even those, that if it's a labor union or competitive business, it sounds like you think those are righteous as well. Do you see any abuses of CEQA? I mean, do you
well, Commissioner Righteous, what a great word, because a lot of those cases are determined to be meritorious. That's what we, lawyers would call it, meritorious or not. So there's a lot that, how do I say it? When cases are filed, judges evaluate them, and judges can work through and shift through the cases that just have no merit. There's actual cases where one has been thrown out because the judge said, well, this is not in the zone of interest. This is not environmental. So that's where I say judges can work through these things. And I guess I would be very concerned with losing the meritorious ones, the ones that actually help protect the environment and all of society and public health, in an effort to constrain anybody from going to court. So it's that separation of the baby from the bathwater that becomes very difficult. And I think judges are very good at doing that.
I have Commissioner Hernandez followed by Commissioner Sidley.
You touched upon it in terms of the judge, their ability, their knowledge. Can you opine a little bit in terms of a possible CEQA court in terms of having expertise of specific judges around the issue?
Yes, thank you, Commissioner. That is a idea that was discussed in the SB 950 or CEQA modernization process, because as we can tell from the discussion, it's a very complicated question, of course. There are people who would be in favor of a CEQA court, designated judges, resources for the judiciary. That's always important. If the legislature is listening, the judiciary needs a lot of resources. And as a matter of fact, that was one of the things that was consensus from everybody. I think developers, public agencies, petitioners, everybody said if we had more judges, these cases would go more quickly, because I think here in LA County, some of the judges I've heard, their docket is 500-600 cases. I mean, that's a heavy docket. And then they're also trying to deal with the CEQA matters. And there are some judges in rural counties that may not have such a heavy docket and maybe, maybe not quite as experienced, but that's okay. Because like I say, they're all trying to do their level best. We actually had one judge who said, well, how do I learn CEQA? What do I need to know before I evaluate this case? And among the recommendations or the things that the parties variously jointly recommended to him was that book that Ms. Thomas referred to, the CEQA guideline. It's a very thick volume. It's like 500, 600 pages. But I guess what I'm getting at is there's also this entity called the Judicial Council, and there are judges' organizations who could potentially be consulted about how to create CEQA courts or new resources for the judiciary. I'm not a judge. I don't move in that world. So I can give a kind of an outsider's perspective about all that, but also point out it is a rather complicated question, and one that there are, experts who can, give more sound opinions on.
Thank you.
Yeah, thank you. As I think as an example, if you're in Los Angeles County Superior Court and you file a class action lawsuit, you're not going downtown. You're going to go to a separate branch. I think it's on Constellation Avenue, where they have judges, and it's for all complex litigation. So you take a look at a place like Los Angeles with the large population, lots of judges, lots of resources. I think they've decided that it is in the best interest of efficiency and in all likelihood justice, that complicated matters of litigation go to judges who have the resources, the time, and the experience to fairly evaluate complex cases. So, I mean, I think we can all agree as we hear testimony from different witnesses, CEQA is a complex piece of legislation that might very well benefit from judicial review by judges who have, almost like physicians, specialized, or some attorneys who also specialize in areas of law. Commissioner Sidley.
Yes, thank you. Mr. Carstens, pleasure to see you again. Thank you for testifying today. Appreciate it very much. So I have a question for you where I want to build on something that you just talked about, where some competitors may file a CEQA lawsuit to avoid a competitive advantage. In that vein, if one competitor comes in and they want to do a project, improve their project, and then a CEQA lawsuit comes along so that they cannot upgrade their facility, and their facility may be older than the competitor's facility, and so they want to upgrade. So is it possible that due to the length of CEQA litigation and the challenge, that in fact the environment suffers because we can't make improvements while we wait for the litigation? And is that an unintended and horrible potential that as we sit in court fighting over this, that we don't see improvements? And they may not be the titular improvement, but it would be an improvement, and potentially if studied, it might be over time that you saw a greater improvement than getting nothing. I mean, is that an unintended consequence that we should at least look at or understand when this CEQA litigation goes on for years?
Well, I really appreciate the question, Commissioner Sidley, because this can help illustrate. I touched on, I might have even quoted, but there's a Public Resources Code 21168.9 that gives judges this discretion to craft remedies. And one of the times that judges will exercise that discretion is when a project might be good for the environment. So there's a case specifically called Poet LLC, where basically industry sued to try to prevent implementation of air quality regulations that would improve the environment. And the court said something to the effect of, well, we recognize that there might be a violation here and we're going to send it back to the agency, but we're not going to stop those regulations from being implemented because those could be beneficial to the environment. So there's again, a discretion and an ability to craft things that it's very hard to foresee something like that, I think the judiciary can be trusted with. And they have carved out these doctrines of, sure, the normal cases, you set aside the entire EIR and all the approvals, but there are exceptional cases in which if certain findings can be made about not interfering with future reviews and not prejudicing things going forward, courts have allowed project approvals to stay in place and for projects to proceed. They won't be stopped unless the court issues an injunction. Another huge example of this is—
well, they're stopped sometimes, aren't they, because of economics, because people can't find financing. But interesting, I mean, your example of regulation is not exactly where I was looking. It would be more towards a company or somebody, let's say, a particular warehouse wants to use near zero instead of zero. And because zero emission doesn't exist today, but near zero does. But instead, there is a lawsuit saying that, zero emission should exist. And if I order it, it will exist. And then it spends 10 years, 6 years in court. What is the benefit that we lost by the 6 years of near zero while we litigated that versus what you've described as a regulation, which is a different situation than what I'm speaking of?
I understand, and I've thought of another possible way to approach that question, because one of the examples of a court not setting aside or stopping everything with a project is the Newhall Ranch project in Los Angeles, which was, of course, that 2016 Supreme Court decision. And after that occurred about greenhouse gas emissions and how to reduce them, on remand, that court allowed the project approvals to stay in place using this discretion under 21168.9. And I contrast that, which, by the way, ended in a settlement. That was another one where everybody sat around a table and actually hammered it out, with kudos to that whole team. I think Ms. Prabal mentioned last hearing about how that turned out. So the project went forward after concerns were taken care of, and what's now called Net Zero Newhall is a shining example for other projects throughout the state to reduce their greenhouse gas emissions in a net zero way. Move forward to another case, which is Tejon Ranch and Centennial, and that is not, and a court has determined, a trial court right now, it may go up on appeal, I don't know, but it determined that it did not address greenhouse gases in a correct way. So I think as a systemic thing, it's sort of like police issuing tickets. They're not going to pull over and ticket every driver who's speeding, but the ones who do get ticketed, it's going to have an impression on everybody else so that they'll be sure to comply with the law. I know I'm very careful to make sure I stay under that speed limit. So even though the cases are very few and far between, and the remedies may be very well crafted, and if you're the one getting ticketed, of course you get really upset, but as a societal matter, everybody else is benefited by compliance with the law.
So I'm just curious if you know the answer to how long both Tejon Ranch and Newhall Ranch have been litigated through the courts. How long has that been going on?
Well, I would love to answer that because I have a pretty good idea. One is with regard to Newhall Ranch, years, decades, and I'm not here to say that that it was short, because there were different things that were litigated at different times. The Attorney General himself, it was a him at that time, came in when there was a trial court tussle over the general plan or the specific plan. It was right in the Santa Clara River. You may guess that I was actually involved in that. Again, we were co-counsel at the Center for Biological Diversity. So that was back in, say, 1999 or 2000, and that was resolved and settled, and sort of things went to different stages, like actual plan documents, like actual subdivision maps, et cetera. And the Newhall Ranch litigation in 2016 actually had to do with a fish and game permit that was issued by the Department of Fish and Wildlife. And it did not comprehend or include an analysis, a sufficient analysis, I should say, of the greenhouse gas impacts of the project. It also affected a fish called the unarmored three-spine stickleback and did not incorporate Native American concerns well enough. But the main thing we remember it for is the greenhouse gas issues. So in 2000, and I think it was about 16, maybe 17, there was a settlement, and people have already built houses out there. The bulldozers moved. You can actually visit. I was invited to come and see people living there, but it took a long time because it was 21,000 units. It was a new city out in North LA County.
I understand. I was just wanted to know, and you've answered it, decades. These things have been in court for decades. That's really, I just putting some perspective on all of this. So thank you.
Thank you.
My other commissioners have questions.
Commissioner Hernandez had his hand up, followed by Commissioner Canella.
Just to follow up on that, I think that the question was twofold, but it sounds like what you're saying is that the delay has never negatively impacted a possible opportunity to improve the environment. Is that what you're saying?
Never's I mean, it's a difficult word to use.
And then two, what I heard too, for the first time ever in the reading, that CEQA was equated to a penalty, that I thought CEQA was an opportunity to improve a project. So the whole comparing it to a ticket probably is not a good analogy.
Oh, no, I understand, Commissioner. That was just by way of illustrating that enforcing CEQA is a law enforcement matter. And it's not a penalty. It's actually a privilege and a process that benefits the whole state. That's why I think it's survived for these 50 years, because how well it has served the state to protect certainly environmental justice communities, but all communities, everybody in California. I didn't read that part of my letter, but at the beginning, I basically waved the California flag about our strong economy, the fifth strongest in the world, and the various things that are right. All of this has occurred while CEQA has been in place for the past 50 years. So I think it not only has helped promote addressing climate change. I think we did hear some of that at the last hearing. The actual addressing of climate change arose out of a Attorney General lawsuit against the County of San Bernardino in 2008 or so. I remember I was around in 2008. I haven't been around as long as, say, 40 years. I've been around maybe 25 years in some of this. But in 2008 or so, there was an effort to introduce legislation. Actually, it was introduced to exclude greenhouse gases from CEQA, because people were shocked at the time that CEQA might actually deal with climate change and greenhouse gas emissions. And after that bill was introduced, I think it was SB 9, I may have the number wrong, but when the legislature considered what really they should do with the policy, they said, not only is greenhouse gas part of CEQA, we're going to make a guideline, we're going to show people how to do that analysis. And ever since that time, greenhouse gases have been a accepted part. So CEQA helps identify problems and it helps address them. So I think that's why when you ask about maybe interfering with addressing, let's say, solar panel installation or some facilities that might help us address climate change issues, there have been projects, there have been lawsuits against solar farms out in the desert that might interfere with Native American tribal resources or desert tortoises. Those are very few and far between, very rare. And there are exemptions and exceptions that have been adopted by the legislature so that those do not become problematic. On balance, the greater thing is to address California's issues and also address when CEQA does become a problem for things.
Thank you. Commissioner Cannella?
Yes, thank you, Mr. Chairman. I'm just curious to your thoughts about how the legislature, how they deal with CEQA and the challenges with CEQA is they pass legislation to work around it, right? So they do fast tracking or exemptions. In fact, I served in the legislature. I'm still friends with a lot of folks up there, and one in particular, which I won't name, is really trying to improve CEQA, in my opinion, improve CEQA. And I said, you know, how's it going? He goes, I don't really care about CEQA. I just passed legislation to exempt it. So it really, you have two different, you know, abilities. People that are connected get legislation to work around it, and you have people who are not connected getting tied up for many, many years. I know you said that most of the public comment was supportive of CEQA. We did have the president of the BIA, who represents thousands of builders, that was not supportive. So if you look at the weight of that testimony, I think it shows that there are a lot of concerns. But what do you think about that with the legislature? If they're really big projects, whether it's Facebook or a sports team, they just pass fast tracking or exemptions to work around it. What's your thoughts on that?
I really appreciate the question, Commissioner, because this has been a sore spot with me, the special one-offs ever since, I mean, I've written about them, I've objected to them since 2010 with the AEG Stadium in Los Angeles, but these have been going on for a long time. CEQA has always, or I shouldn't say always, but for a long time, maybe 30 or 40 years, involved and accepted particular things. There are these things called categorical exemptions, which set aside, you know, a whole thing. But then there also is, as Mr. Alling mentioned, statutory exemptions. The one I keep remembering and I find most humorous is the Napa Valley Wine Train. I mean, Napa Valley Wine Train, somebody got a special exemption so they wouldn't have to study that as a CEQA matter. There are also very important exemptions or exceptions, like for building prisons. So there was a whole kind of wave back, I think it was in the 80s or 90s of exemptions and exceptions for important public infrastructure. But then you move forward in time to 2010 or so. That was the first time I saw what I call monetizing CEQA, a sort of a trade-off. We'll give you an exemption for a special deal that you can do for the state. And in that case, it was about creating jobs. You know, people went around and said 1,800 jobs. We're going to create this by building a stadium. And they got the exemption. It was, I think, 292, maybe a SB 292. And the stadium never got built because there were other reasons. It wasn't CEQA that was stopping the stadium from being built. It was I think, National Football League or whatever the contract issues. So people blamed CEQA and said this was going to get in the way. And then when they got CEQA, you know, an exemption, it turned out it wasn't CEQA after all. So it's a strong word, but I hate exemptions. I just wish that nobody would pass them, but realistically, I recognize people see the need for them, and it's part of the weighing and balancing process. And there's actually a statute now because, as I mentioned, in 2010, there was this one-off, and then a couple of years later, there was another one. I think it might have been in Walnut or Irwindale. And so 1 year after another, and then finally the legislature, I think it was Senator Steinberg himself, said, why don't we pass a law, the Leadership in Environmental Project Statute, that sets some criteria for these rather large projects, and then they can have an expedited process, 270 days or so, and we'll still subject it to CEQA, but we'll not have it, going 2 or 3 years in the courts. And so it was a trade-off. The Judicial Council hated it. They opposed it. They oppose every one of these exemptions. I've known the person who's done these letters. And so I wish, I wishes and horses, that expression. I wish that we didn't have to do exemptions or exceptions to CEQA, but I also recognize as a practical matter, there are reasons for them. There's also beneficial exemptions. There's exemptions for renewable energy projects and for affordable housing. One of the more extensive sets of exemptions is for affordable housing and infill. I think Mr. Hecht, in his letter to you the first day, detailed one statute after another that gave special treatment to affordable housing, because there are certain policy priorities that I think need to be recognized. And CEQA is not the be all and the end all. It is possible to promote other policy priorities in California and yet still have a strong CEQA.
So if I could follow up on, that point, we would all like to, as you pointed out, the judiciary is quite strong and quite capable. I'm wondering, can you craft a law where we don't need the exemptions? Why are some people treated differently? Why isn't there a CEQA law that everyone gets the same rules and lives by, and these exemptions aren't necessary? I mean, the mere fact that there's exemptions seems to speak to the fact that there may be some concern about how CEQA operates. So wouldn't it be in the best interest of all of California if there was a law that was crafted that worked for everybody? And can you suggest what that might be?
Commissioner Sidley, I am so glad of that opportunity. It's almost as if you're asking for me to just bring onto the table this SB 950, which is a whole thick law that was proposed in 2020. It was a whole set of recommendations that was worked out on how to make the law better. We don't necessarily need a new law, but we can improve and amend the law we've got, which has worked so well, because I think drastic kind of swing for the fence kind of changes are very problematic. But there are ways to improve both the administrative review process and the litigation process. Things like the administrative record preparation, which can take months in some cases. If that were something that the public agency were to do right when they were reviewing the project and it was ready on day one, which is how some of the current legislation deals with it.
Have you done it? Have you done one of these records to understand how difficult it is for maybe being done day one?
I have. I certainly have, Commissioner, and I also recognize it's very costly. You can't do these records for every project out there because there's only 2% or less that are going to get litigated. So in the,
and that's taxpayer dollars to
taxpayer dollars.
Do that.
In the ninth process, there was a whole discussion because it included public agency people and developer representatives and other groups, environmental groups. So in that process, there was a discussion of setting up a whole way to deal with these administrative records and then making it elective. Because if the public agency or the real party in interest did not want to incur these costs, or for whatever reasons, then the other process can apply. And in CEQA currently, there is a requirement that the public agency designate or certify the administrative record at the time of approval. It's a very, very disregarded provision in CEQA, but it's currently there. So that's one litigation related improvement. I also mentioned in the letter the ways that I just identified 3, but there's probably a dozen or more. In CEQA, there was probably 35 or 36. I mean, in SB 950 and the CEQA modernization discussion, probably 35 or 36 items on the white paper to say, can we deal with this? Can we deal with that? The 3 that I really would promote are including environmental justice in CEQA. That is something that the Coastal Act already has. I think last time somebody had mentioned that it is well defined in statute, but CEQA, in some people's view, doesn't deal with it. There is a trial court that said that it is required, but that's a rare instance. And we would like to see that. Environmental justice is a placeholder for democracy. There's a way to more democratize these processes, and recognizing environmental justice is part of CEQA, is one of those. Also including accessibility. That means possibly posting electronically documents. We're in 2023, and the statute was written before there was email or the internet. I mean, Google, what was that, 1990s? So we're in 2023. There should be a way to make these documents more accessible electronically to everybody. That's one of the difficulties. And possibly translating some of them, not all, again, it's a cost issue, but translating where necessary, where monolingual communities can be served. If Spanish or Korean or Chinese is all they speak, they should be able to participate in processes as well in their own language.
So Mr. Carstens, I appreciate these 3 suggestions that you've made, but none of those would address the issue of exemptions, of having to go and you're doing a football stadium and that becomes an exemption because it's costly, because it's time consuming. Your suggestions are very interesting, but they're all more costly and time consuming. So I guess what my specific question was is, people only go for these exemptions because otherwise the process takes too long. And so I think what you're just hearing from this commission, and part of the thing that you're hearing from other people who are testifying, is that it's very time consuming, it's very costly. Although you might say that 195 cases a year is a small number, I think it actually is quite a large number for potential projects, housing projects, when there's such a dire need for housing in California. But again, I appreciate your testimony, and I certainly appreciate your ideas, but I don't think candidly that they address why people are going in for exemptions on specific projects. I think sadly, they may actually precipitate even more exemptions. And that's, I think what we're looking for is a law that everybody can use, and everybody can use fairly, without going in, as Commissioner Cannella said, going in and saying, I don't care about CEQA, I'm just going to get around it. I don't think that benefits anybody. But if it continues to be something that's so challenging, I think that we're seeing people go around it. So that's the vein in which I asked the question, but I do appreciate your answer. So thank you. I'm done.
Well, thank you. May I add to that? Because it was something that the earlier panelists, thank you, Chairman. Curtis Ailing mentioned this possibility of final EIRs having a comment period, and that could reduce it's all trade-offs, it's all balancing, because if you restrict public comments in one way, there should be an increase in accessibility in other ways. Otherwise, you're just cutting down on participatory democracy. That idea of having a comment period on a final EIR, it seems to have merit, and it was something that was discussed in SB 950 and is actually one of the drafted sections in this 2526 section proposed legislation that never made it out of committee because of the IA opposition. So that idea of administrative records or rearranging the administrative review process has merit if done in a balanced and a way that incorporates everybody's concerns. There's always those people who only hear about the public hearing the day of, or they're watching cable TV and they'll come down to the city council in their bathrobe. There are people who don't participate in these processes a year or two from when it first appears or there's a notice of preparation, and they only hear about it at the time when it matters, when it's going to their elected officials. So we try to, I think, incorporate and address all of those concerns and recognizing and validating the concerns about cost and the 11th hour comments. Some people call them late hits. That's a violence analogy. I don't like violence. It's not a hit. But 11th hour comments that might be thick can reflect new information that just came in or people became aware of. And the public agency has a chance to deal with that. They could set another hearing, or they could have staff, I've seen it done, work overnight to have a staff report the next day. So public agencies are given these chances to resolve at that level where it should be resolved, 98% iceberg under the water. And then if it's not resolved, there's the court remedy to address potential illegalities. But there are ways to improve both the administrative review process and the judicial review process to expedite, litigate, and I mean, not litigate, but streamline in certain ways, which a lot of those were discussed in SB 950 and the CEQA modernization discussions.
Yep, thank you. I'm looking, I see no further hands from commissioners. One of the things I think that that we must be conscious of and be concerned about to a certain extent is not chasing the headlines. There can be a real injustice done when a complex matter is reduced to a headline. So when you see a newspaper story that characterizes an issue in a way so that it fits across the top of the page, it in all likelihood is not going to reflect nuance and complexity of the issue. You're going to have to read past the leading paragraph and further on into the story. And one of the things that I heard today that I don't think that factored into my assessment of the CEQA issue is, for example, when we hear that a project took decades, we really owe it to an analysis to comb through that. Which part of that related to CEQA? Which part of that was because of federal regulations and an analysis? So if Fish and Wildlife on the federal side brought something forward, that's not a CEQA problem necessarily. If there are water issues that are not related to CEQA, but they're brought forward through the State Water Resources Control Board, that adds time to a project, that's not a CEQA impediment. So I think in order to have a discussion about how we reform CEQA, we've got to be conscious of isolating those CEQA impacts so that it doesn't get conflated with something else that happened that contributed to a delay. And one of the areas that I'm very, very interested in, and we've had testimony about it, and in Mr. Carstens' recommendations, it's included as well, is the significance of communities of color and how the CEQA process does provide, perhaps for the first time, a theater within which those concerns can be heard. Because we know for too long, what are now called fence line communities have borne the brunt of certain kinds of developments. I mean, go to Wilmington. I don't think anybody here would willingly sell their home. I live in Santa Barbara. I ain't moving to a refinery. I don't think any one of us would voluntarily go to a place that has a higher incidence of illness and cancer and respiratory disease. We wouldn't do that on our own. So there are aspects of CEQA that do act as a shield for people who ordinarily have no money, no power, and no voice. And as we discuss reform of CEQA, that is going to be one of the areas that I'm going to be very conscious of, to ensuring that we don't deprive people of that ability to articulate for themselves impacts that they will be feeling for a very, very long time. And the other element that is really interesting as we have this conversation is it seems to me that there's some part of this that rests with the judiciary. Whether or not you have judges who are experienced in CEQA and then who make decisions that don't seem to be consistent with prior direction. So you can't really blame CEQA for that. If you have the exercise of discretion by a member of the bench that departs from guidelines and those areas that have been carved out already, that's not a CEQA problem. That's a judicial problem. And I'm glad that we're having these conversations, because like Commissioner Hernandez, we all haven't necessarily been invested in peeling back the onion on CEQA. Are there issues? Of course. I mean, we don't have the kind of testimony that we have from advocates and from other observers of CEQA. We would not be having this conversation if there weren't some things that have bubbled up that look to be issues that need to be resolved. So I have no quarrel with that. But I do think, and Commissioner Sidley made this point a couple of years ago, we probably are one of the best bodies that can rationally and objectively and dispassionately comb through this topic and evaluate where to make the changes so that we can reduce some of the noise that has to do with CEQA. I'm going to tell you, when you're talking about development, you're never going to get away with, you're never going to resolve all of the issues, because there's too much money, there's too many impacts, and there's too many people's lives that are going to be affected by it. So, but I do think that we're on the right path, having this kind of detailed conversation about what we see as remedies for what has surfaced so far. And we've got 2 more hearings to continue to do this in. I want to thank you, Mr. Carstens, for your testimony. And let me turn it over to Ethan. I think we're probably now at public comment. We've had as many as about 130 participants. We're down to 113. So let's see how many of those folks want to take the mic.
Thank you, Mr. Chairman. So we will move now to item D on the agenda, which is the public comment period. For members of the public who wish to make public comment, if you have joined the meeting via Zoom, please use the raised hand function in Zoom. That's the best way to tell us you wish to make public comment. If you have phoned into the meeting, you may email us immediately at littlehoover@lhc.ca.gov. That address is on the screen, littlehoover@lhc.ca.gov. Give us the phone number from which you have called so that we know who to unmute if you are called upon to make public comment. Again, however, if you have joined via Zoom, simply use the raised hand function. In keeping with the Commission's traditional practice, each comment will be limited to 3 minutes. Commissioners will be able to hear you but not see you while you make public comment. The entire public comment period at this hearing is limited to 30 minutes total. We will, of course, have additional public comment periods in the next 2 hearings to be held on CEQA. And if you are not able to make public comment at a hearing, you may always email us at that Little Hoover address with public comments, and those will be incorporated into our research process. So with that, we'll move to public comment. Again, 3 minutes per speaker, and we do have a number of people on the attending the meeting, as the chairman mentioned, so please limit your comments strictly to 3 minutes. With that, I'll ask Ashley if we have anyone who has indicated a desire to make public comment.
Yes, we do have a queue ready to go. We're starting off with Joanne D'Antonio. Joanne, I'm turning on your ability to unmute yourself.
Thank you. I serve as a Los Angeles City Council appointed representative on the Community Forest Advisory Committee, and I am the founder and chair of the Neighborhood Council Sustainability Alliance Trees Committee. Today, I speak as an individual who has spent 8 years as a dedicated tree advocate in Los Angeles. Let us not underestimate the value of CEQA. I am sad to hear of abuses today because it is the most significant tool in our effort to save the environment. Without a robust CEQA, we are just giving California over to developers who see land as there to exploit and giving a free rein to city departments to destroy environmental assets for other goals, including budgetary priorities. Yes, CEQA challenges feel like they take too long, but it is all we have right now to at least get some environmental consideration for projects. A very recent example in Los Angeles is the challenge to the city sidewalk repair program, in which 2 independent environmental groups successfully sued the city that the EIR comments were not adequately addressed. And the CEQA judge ruled, citing the EIR comments of the Community Forest Advisory Committee and LA Audubon, that the removal of thousands of street trees would impact tree canopy, and this would not be mitigated by the replanting plan offered. He said that birds cannot wait for the new trees to grow and provide habitat. This judgment that halted tree removals in the sidewalk repair program, this caused the city to pass a motion to find alternatives to tree removal and apply for funding to execute these. If there is any concern about how CEQA worked here, it is that we are now seeing street tree removals for sidewalk repair that is categorized as not part of the official sidewalk repair program. So yes, I do fear workarounds, and I would like to see a way to prevent loopholes that violate the spirit of a CEQA ruling. Furthermore, the sidewalk repair program went forward before its EIR was certified, so hundreds of canopy street trees were cut down during those years. How is that possible? I also want to point out that it has gotten harder to cite CEQA on smaller projects in which trees are removed to put in swimming pools and tennis courts on trophy homes. Most of these are spec projects, not to fulfill an individual's needs. If anything, I feel we need stronger ability to cite CEQA because more and more has become categorically exempt from CEQA. Urban woodlands in LA are wrongly considered infill, and it is destroying habitat. These exemptions set a bad precedent, and then everybody wants them. As it is, we have property development that removes all trees and builds lot line to lot line. Exemptions invite detriment to the environment, and affordable housing dwellers need a healthy place to live. We are creating environmental injustice when we waive CEQA for these projects. Without CEQA,
Ms. D'Antonio, your 3 minutes has expired. Please wrap up quickly.
yes. Without CEQA, we may as well give up and say environment is lost in California and tell residents to go elsewhere. As a volunteer tree advocate, I have taught and sponsored workshops on how to effectively comment on an EIR MMD. It is difficult.
Thank you, Ms. D'Antonio.
Thank you.
Thank you. Ashley.
Thanks. Next, we're moving on to Nikki Miner. Nikki, you should now have the ability to unmute yourself.
Yes, good afternoon. Thank you for all the very interesting testimonies. I represent myself, but I'm part of the Benedict Canyon Association and the Bel Air Beverly Crest Neighborhood Council. We've come across many situations where the CEQA is a blessing, it's a help, it helps save the community. I think the streamlining is another word for undermining the CEQA situation altogether, and it needs to be strengthened and not weakened. And just because there are a few litigations that have taken many years, this does not give way for undermining the CEQA as a whole. And I really would like to encourage a hardening of it and give more opportunity for citizens to be able to preserve their communities. It's very difficult when citizens who are volunteers are not paid, who don't have jobs to fight these things, have come across builders with unlimited funds to override the citizens' questions and problems. And this is what we're all fearing. And this is what we hope that you will take into consideration and consider hardening CEQA as much as you possibly can for the benefit of the citizens who are being overrun by all these projects. Thank you.
Thank you, Nikki. Next, we're moving on to Gloria Sefton. Gloria, you should now have the ability to unmute yourself.
Thank you very much. Good afternoon. My name is Gloria Sefton. I'm an attorney and vice president of Friends of Harbors, Beaches, and Parks. We're an Orange County nonprofit established in 1997 with a mission to promote, protect, and enhance the harbors, beaches, parks, trails, open spaces, natural preserves, and historic sites in Orange County. We engage a coalition of some 80 conservation and community groups who support our regional work. A large part of our mission involves protecting the natural environment, which generally goes hand in hand with reducing sprawl and mitigating impacts of climate change. Our organization also supports environmental advocate partners in various parts of Orange County. In some instances, we and our partner organizations have challenged inappropriate development plans under CEQA, where the project was either inconsistent with planning and zoning law or where environmental impacts could not be mitigated to insignificant levels. Since 1970, CEQA has been the framework under which new projects have been publicly disclosed and analyzed. CEQA provides the tools that the public needs to understand the impacts of a project and the tools decision makers need to decide whether those impacts are properly mitigated. We've seen firsthand how CEQA can make projects better. In projects we've been involved in, CEQA has improved impact mitigation, safeguarded regional parks, protected open space and habitats, and even funded fire protection in a very high fire hazard severity zone. Fundamentally, CEQA is the guardrail keeping California beautiful, healthy, and livable for plants and animals, including humans. And CEQA's framework provides a transparent and open public process for doing so. CEQA is being criticized as being used as a cudgel to stop project, but it's really important to point out that legal actions under CEQA are not the norm. We always choose to avoid litigation. Thanks to CEQA's disclosure and analysis requirements, parties are brought to the table where creative solutions can arise. We urge the Commission to recommend securing CEQA to keep it strong, especially with challenges to our environment from climate change, and to continue to encourage public participation in evaluating projects that have an impact on California's citizens and its rich resources. Thank you so much for your time and attention.
Thank you, Gloria. Next, we're moving on to John and Michelle Hales. You should now have the ability to unmute yourself.
Yes, my name is John Hales. I'm a resident of Northridge, California, local to Los Angeles. I think this particular meeting is critical in sharing the information on CEQA. However, until Commissioner Sidley brought that word up, exempt, that was not mentioned in the previous section. I would like to say I have visited several projects, reviewed the projects, and when I saw the word exempt, it literally made me wonder, what in the world did they get an exempt status on this for? I'm unable to, on most of those, find a reason. One particular one that I bring up is there's one in Northridge. It was a huge project, multi-million-dollar project. It was initially set with the setback of 15 feet. That dropped down to 5. It was built directly next door to a school and adjacent to a church. They got exempt status. And as a result of that exempt status, they continued to finish the project. And that started in 2015. What we have right now, half the project has not been completed, and the neighborhood is a mess. There are vacancies being filled in there without the knowledge that the second half of the project has not been completed. And from what we understand, the owner is not interested in continuing the project. This particular project was approved and pushed through with a city councilman that, oh, by the way, just finished his 18 months in prison for bribes, etc. I really appreciate what you're doing. CEQA is critical. They took down 12 oak trees and they never replaced them. It's something that is something very important for all. And thank you so much for the opportunity to speak.
Thank you. Next, we're moving on to David Caden. You should now have the ability to unmute yourself.
Yes, thank you. I'm speaking on behalf, I'm the president of the Benedict Canyon Association, and I'm speaking on behalf of the association to support CEQA and not have many exemptions to it. Benedict Canyon is particularly vulnerable to wildfire. We're in an extreme hazard fire severity zone as denominated by the fire department. There have been wildfires there before, and we're very susceptible to them, and CEQA would act as a buffer against it. And then overdevelopment is also a problem by destruction of flora and fauna, which promotes climate change as well. It aggravates the possibility of wildfires, et cetera. And so just simply state, we strongly and vehemently support CEQA and do not want to have the many exemptions that are being proposed. And we thank the commission for hearing us.
Thank you. Next, we're moving on to Ray Chandos. Ray, you should now have the ability to unmute yourself.
Yes, am I coming through?
Yes.
Thank you. Yes, my name is Ray Chandos with the Rural Canyons Conservation Fund, founded in 1983 to promote public participation in land use decisions affecting our environment here in southeastern Orange County. Regarding CEQA litigation, I think it's important to note that CEQA is citizen enforced, and I would like to briefly share with you our experience as ordinary citizens who have had to step in and enforce CEQA through litigation. The barriers are numerous and formidable. First of all, funding. Funds must be raised usually through small contributions from a large number of people to cover legal representation, the administrative record, court filing and service fees, and the court fees of the opposition if we lose. In contrast, there normally are multiple well-funded opponents, a government decision maker and one or more real parties in interest. Once as a pro se plaintiff myself against a city, a toll road agency, and a developer, I was in court against 7 attorneys on the other side. There are also legal barriers. CEQA's short 30-day statute of limitations, the substantial evidence standard of review, and the general judicial deference to the decisions of public agencies. All of this just to have one's day in court with no guarantee of success. I can relate that one of our members actually mortgaged her home to help pay for a lawsuit that ultimately failed at the appellate level. So it's always an uphill battle for us, and the last thing we want to do is file a frivolous CEQA lawsuit. We've undertaken CEQA litigation always reluctantly and as a last resort, and only to challenge decisions that are clearly out of bounds. To conclude then, I'm not sure of the scope of your commission's possible recommendations. I do hope that outright repeal is not being considered, but I would urge that the public notice and information disclosure provisions not be abridged, and that no further barriers to citizen participation and enforcement be established. Thank you very much.
Thank you. Next, we're moving on to Ryan Walter. Ryan, you should now have the ability to unmute yourself.
Thank you. I appreciate the efforts and the work of this commission very much, and the opportunity to be heard and to bring democracy this way. I think a lot of the focus of my comments are going to go on Chairman Nava's comments about people who have no power, no money, and no voice. We could look at redline communities. Now, as this is typically seen as communities of people of color, I think now through Chevron doctrine, now this is going to be hard to focus into a grouping here. Chevron doctrine with administrative law, as I have seen heard much today about creating a CEQA court. We have to be careful not to give too much power to the executive branch, as they've done in child support services, creating redline communities such as non-custodial parents. And what does this do for environmental quality for children? Well, if we see, I'm sorry, I cannot minimize my screen to see. They're under public trust doctrine. We see children in Oregon suing the federal government for air quality. Now, if that is an environment, I think that the public trust doctrine and CEQA go hand in hand. I think it's pretty much the same thing. And so if we think of the environmental quality for children and their parents, we can then transmute this over to housing as Mr. Allings goes into, and then we have a collision of different policies. We have HUD housing first. We could buy blighted houses, create jobs for non-custodial parents to build the houses into marketable homes, solving many problems all at once. These are just some things I want to put a bug in the ear of the commission. But what it really comes down to, yes, our judges are very smart people. The judiciary they are doctors, yes, and of the law. And our administrative law judges are not. Our administrative law judges are bad attorneys who needed a better job. They should not be given the power of the legislature. Chevron doctrine must be removed. Citizens for Prosperity v. Bonta began to remove Chevron doctrine, and we need to keep that going and not give any more power to administrative law. If we create a CEQA court, it needs to be removed, kept from administrative law, from the Office of Administrative Hearings. And at the same time, if we're going to do this kind of sort of administrative law in the judiciary, let's remove all of the administrative executive branch delegated legislative duty and just bring it all to the judiciary and separate it back to the legislature. Get the
Mr. Walter, your 3 minutes has expired. Please wrap up quickly.
Yes, sir. Thank you. That was the point of my thing. CEQA is going to be a court. Let's keep it in the judiciary. Thank you.
Thank you.
Thank you. Next, we're moving on to Alan Levin. Alan, you should now have the ability to unmute yourself.
Okay, I think I did it. Good afternoon, commissioners. Thank you for the opportunity to talk to you. My name is Alan Levine, and I'm director of Coast Action Group. CEQA offers the only ability for the public to participate in an informed decision-making process regarding projects. As director of a Coast Action Group, I've participated in many hundreds of CEQA processes, most of them certified regulatory programs. So I want to make the point that all CEQA projects are not related to housing. The certified regulatory programs are really important programs. Forest practice rule writing at the Board of Forestry, timber harvest plans come under that. DOGGR, the Division of Oil, Gas, and I forget the rest of the resources. I sat in a meeting with Daryl Steinberg and Kevin DeLeon, and I said, this is a mess, and you got a mess there because their environmental review was terrible, injecting polluted water into groundwater. Water quality policy and rule writing, permits, waste discharge requirements, waivers, cleanup programs, TMDLs, they are all CEQA based. Now, as far as delays are concerned, which is a subject that came up, many delays are related to the failure to supply data and needed information to complete the environmental documentation and review. It also was brought up that there's no skin in the game for the public when they approach potential litigation. It is very expensive to litigate. If you lose your money. You have to pay for your lawyer, the court costs, and the additional the record costs too. And that becomes quite onerous fiscally. It's hard to raise that money. As far as the exemptions are concerned, the housing exemptions, though they might help with housing, they do not consider water supply availability. And that's another issue that we need to look at. We didn't have water before, we have it now. We don't, we might not have it in the future. And that issue needs to be looked at. If people are going to live, they're going to need the water to live by and use to sustain life. And there needs to be water in streams to sustain fishery and other aquatic resources. So I think, I can give you examples of projects that I've worked on and litigated on and never lost a lawsuit, maybe 4 or 5 CEQA suits in forest practices.
Mr. Levine, your 3 minutes has expired. Please wrap up quickly.
Right. And in all cases, in all the projects that I've participated in, they have ended up being approved and being better projects in the end. Thank you.
Thank you, Mr. Levine.
Thank you. Next in line, we have Marcia Hanscom. Marcia, you should now have the ability to unmute yourself.
Thank you. Can you hear me?
Yes.
Great. Honorable Commission members, thank you so much for having this item before you. I really appreciate it. I'm with the Defend Bionah Wetlands Group and Coastal Lands Action Network. I live on the coast of Los Angeles, and I've worked for 30 years to protect wetlands, coastal habitats, wildlife, and imperiled species. I want to say something that I haven't heard about, and that is that something that was not in the original CEQA legislation and that was added, and that's a big problem in my view. If there's something you want to change, remove overriding considerations, because basically overriding considerations means that any agency can basically approve anything and just have a statement saying, well, we need more housing, well, we need more this, we need more that. And a lot of the agencies don't use it, but a lot of them do. And a lot of the big developers with big law firms use that very frequently. And if you have an overriding consideration, it really doesn't matter if there are environmental impacts. So I think we should take that out if you're going to change anything. I also want to talk about the fact that we have a biodiversity hotspot here in California. We're in a crisis. We don't live on this planet alone. And now it's understood by scientists, and even our governor has stated that we need to preserve 30% of our lands by 2030 if we are going to not have the worst of climate impacts upon us. Scientists are now saying it even may need to be 50%. And that's because not just the open space, but species like pollinators that our food supplies rely on are a critical part of the environment, and we rely on them. Humans just don't live here by ourselves. And when we talk about exemptions, one of the things that's really got me worried is that the governor, weirdly, given his concern about climate, he talks about cutting green tape, he and a lot of people in his administration. And I'm worried about that because there are projects that call themselves environmental. Sometimes they even call themselves restoration, like the project proposed for the Bionah wetlands. We're currently in court under CEQA, but if we were to go under the new proposal for removing, quote, green tape and not having CEQA apply to a project like this is not a restoration. It's a huge, big project that would bring in bulldozers, excavators, remove habitat for 7 endangered species. And if we didn't have CEQA that we already were fortunately able to get in under the wire, we would not be able to, we're working to protect these species now in court against our own government, unfortunately. So
Ms. Hanscom, your 3 minutes has expired. Please wrap up quickly.
Great. So I just want that whole idea of green tape to be re-looked at and reviewed. Thank you.
Thank you.
Thank you. Next, we're moving on to Wendy Sue Rosen. You should now have the ability to unmute yourself.
Yes, good afternoon. I really want to thank the presenters of what you called witnesses today. I thought this was a very interesting and insightful conversation. I'm concerned about the focus on the exceptions here, on the time that it takes for those few cases, and that we might be changing rules in response to that. I really think we should focus on how CEQA really works and when it works for most of the cases. I also think we should look at when the courts are looking at these projects, what are the results? How many of these, the numbers that I've seen is that not only are very few litigated, but many of them that are litigated have not only, claims that are valid, but that they win in court. And many people said what I would say about the climate crisis and how important CEQA is. But I think sometimes the government, we have a housing crisis. And so we're so super focused on the housing crisis. We're talking about exempting all kinds of housing projects. But trees and animals and wildlife and pollinators are so important. Are we also making sure there are some boxes checked to ensure that heritage trees that provide the cover that we need so that we don't continue warming our planet are also preserved? Because what I'm seeing in Los Angeles, where I live, is lots of trees being taken out to make room for housing. And we're creating concrete and asphalt everywhere. We don't have the infrastructure, and now we're taking out the kinds of natural resources that we need to protect our civilization. And, we're in a climate crisis, we're in an emergency. And I didn't hear any conversation from the commissioners worrying about that. I heard a lot about the time it takes. I heard a lot about the housing crisis, but I think we also need to be talking about the emergency that we are in and what does that mean for the changes that you're looking at. If you're going to make changes, we need to make sure that we are not continuing the warming that's occurring, and to remove the natural resources that are the only things that we really have to protect our environment. So I appreciate the opportunity to speak. CEQA for us is the only opportunity, as somebody said, to give input into the process to address potential impacts on the community. And so I hope you will really look at this with an eye toward the democratic process and protecting the citizenry. Thank you.
Thank you. Next, we're moving on to Sean Hecht. Sean, you should now have the ability to unmute yourself.
Thank you. My name is Sean Bekta. Thank you, commissioners, for having this meeting. Also, as a CEQA practitioner, thank you for bringing CEQA practitioners in to provide testimony. I will give the standard disclaimer that others have, that I am speaking just for myself and not for any other entities or organizations I may be affiliated with. Speaking to one of the commissioner's questions about data and data sources as far as what happens with CEQA and CEQA cases, I just want to point out that one aspect that I didn't hear at this this commission hearing or the previous was situations where a project never gets to the CEQA process. And so I've had direct experience with projects where someone comes in to do an opportunities and constraints analysis. Do I want to do this project? A specific one being a green cement or green concrete fabricator, knowing that they would be litigated through the CEQA process by one of their competitors, an already existing concrete manufacturer. They looked at the timeline. We gave them the information on how long it would take to go through the CEQA process, go through litigation, and their ultimate decision was not to pursue the facility in California. So just pointing out that, using the same analogy of under the iceberg on that, what happens with CEQA data, there's some under the iceberg experiences that aren't going to show up in any records and in any direct experience with a CEQA lead agency. Then talking about another commissioner's question about whether EIRs or CEQA documents are getting longer or more complex. I would just say that anytime the legislature adds an issue to the CEQA process, EIRs are going to start getting longer. And I'm not going to comment on the merits or value of any of these issue areas, but when you add on wildfire, when you add on tribal cultural resources, when you add on climate change, each one of those is going to make CEQA longer. It's going to be more costly to pay people like me to write those EIR sections, and it's going to provide another avenue for litigation. If you accept those facts, then the converse would be if you remove any issue areas, then the CEQA process should be streamlined, less time consuming, less costly. And I'll just offer as one simple idea, and I realize this is just nibbling around the edges, but we could declare a win in the area of energy conservation. So that is one element of the CEQA process. And I think through existing legislation, through the green building codes, through a lot of other regulatory and processes in California, that I have a hard time imagining a project in California resulting in a gratuitous wasting of energy. And so that would be an option to take out an area in the CEQA process through legislation.
Mr. Becta, your 3
yes.
minutes has expired. Please wrap up quickly.
Thank you. I'll just say specifically Appendix F. Thank you very much.
Thank you. Next, we're moving on to Lois and Mark. You should now have the ability to unmute yourself.
Hello, commissioners. My name is Lois Becker, and I live in Bel Air Skycrest on the Mulholland Institutional Corridor in Los Angeles. California has the good fortune of being extraordinarily rich in natural resources. These resources have drawn people from all over the world, and for many years they seemed inexhaustible. But they are in fact finite, and it is up to us as stewards of this beautiful land to protect what is left. As residents of an environmentally sensitive wildlands-urban interface in the Santa Monica Mountains, the Bel Air Skycrest community relies on CEQA as the single most important tool in our toolkit for protecting our remaining open space, native habitat, and wildlife, and for maintaining the always precarious balance between development and preservation. Development is impactful, and projects must be evaluated and then implemented in a transparent and accountable manner with appropriate mitigations. CEQA makes this possible. Like other speakers today, we have seen how CEQA makes projects better. The biodiversity clock is ticking, and we are all stakeholders in an environment in crisis. Please tread carefully with CEQA and do not deprive us of this absolutely essential tool. Taking away CEQA or its power would in essence be a disenfranchisement. Thank you.
Thank you very much, ma'am. Mr. Chairman, we have reached the 30-minute limit on the public comment session for this meeting. I'm aware there are some people who have indicated a desire to make public comment. I will say to those members of the public, we will have 2 more hearings on this topic. The next is 2 weeks from today on April the 27th at noon, also to be conducted via Zoom. Then we will have another hearing on this topic on May 11th, also at noon via Zoom. Each of those meetings will, of course, have a public comment session. And so I would invite you to make public comment at a future meeting. To be informed of those meetings and receive a link, you should go to our website, which is lhc.ca.gov, lhc.ca.gov. Click on Contact Us and subscribe to our email list. You'll receive notice of future meetings and links for how to join those meetings. You may also, of course, email written comment, as I mentioned earlier, to littlehoover@lhc.ca.gov. Mr. Chairman, I think that concludes the agenda.
Thank you very much, Ethan. Again, my thanks to the witnesses. Thank you very much to staff for once again putting together a meeting flawless. Commissioner Hernandez, congratulations. You got to see what you signed up for. Looking forward to seeing all of you. Looking forward to seeing all of you again on April 27 and May 11. Thank you and stay in good health.